Good afternoon, and thank you for attending the second part of the Estate Planning Educational Tract. My name is Kieran Leva. I'm a senior financial consultant and partner at Senecal Lyons and Associates Private Wealth Management. A little bit about ourselves for those attending for the first time. Our family office provides comprehensive and complete financial planning services to successful business owners and professionals, as well as to high net worth families with complex financial planning needs. So we regularly produce presentations that address specific aspects of the family office financial planning and asset management services. Previous recordings can be found on our website at senecallions.ca. If this kind of topic material interests you, our website is posted on a lot of the slides at the bottom throughout the presentation, so keep an eye out for it. So the estate planning educational tract is designed to provide important insights to help our clients ensure that they manage risk of unexpected events and that their final wishes are well thought out and achieved. The second installment in today's presentation aims to highlight important aspects of substitute decision-making and effectively managing a loved one's estate. So a couple of notes before we begin. Our presentations are interactive, so we do encourage you to use the Q&A function at the top of your screen if you have any questions throughout the presentation. We'll get to as many of the questions as we can at the end of our presentation, if we can't get to yours or if we run out of time. So if the questions are general in nature, we'll share the responses with all the attendees here today. But if the question is more specific to just you and your situation or something that you might be dealing with, we'll respond to you individually. So finally, a bit of a disclaimer here. The contents of today's presentations are meant to be conceptual in nature and in no way are to be taken as specific advice. Everybody's situation is unique and different, and any of the strategies outlined here today would need to be considered in the context of your individual circumstances and may not apply depending on the particulars. So before we dive into the agenda and begin the presentation, I will take a moment to explain how estate planning fits into a financial plan and our process for working with clients. So estate planning and wealth transfer is a specific component of a financial plan, but it's not in and of itself a financial plan. Saying I want to take care of my family or give X to charity through my estate is a nice sentiment, but if your retirement has not been tested to ensure its success, your estate may not have enough to meet your goals. So for example, what if your investment returns aren't what you expected? What if inflation is higher in your retirement than anticipated? What if you get sick and you can't work prior to retirement? So one of the core principles of our family office is that financial planning should be comprehensive and should consider various relevant factors of your financial plan in conjunction with one another. To ensure a client's plans are successful, we take the time to understand the variety of factors that will play a part in their financial situation. So whether it's managing your cash flow, planning a major purchase like a home or a cottage, or preparing for the unexpected like death or disability, reducing your tax burden, or planning for and transitioning into retirement. We work with our clients to ensure that they understand how each factor impacts one another to ensure a cohesive plan is created and to provide certainty in all areas of their financial future. They're really at the center of everything that we do for our clients. So additionally, as a family office, we're happy to include all relevant family members in the planning process, providing them with financial information to our clients' parents or children, or preparing financial plans for their benefit as well. So on to today's agenda. So these are the topics that we'll be reviewing this afternoon. We will start with a quick review of the relevant concepts from our first estate planning presentation, and then we'll be discussing the most important considerations when it comes to being someone's attorney or their executor. So presenting the second installment of the Estate Planning Educational Tract is Pierre Senecal, Executive Financial Consultant and Senior Partner at Senecal Lyons and Associates. So Pierre has years of experience as a business owner in the fields of manufacturing, land development, construction, and of international trade and finance. So Pierre specializes in providing advice on financial, tax, and estate matters to our high net worth business owners and professionals. In addition to being a CPA, Pierre holds many industry-leading designations, such as the Trust and Estate Practitioner designation and Certified Executor Advisor designations which are both very relevant for today's presentation. So these designations, among many others, make him one of the top financial planners in our industry. So with that, Pierre, I'll hand it off over to you. So please take it away.
Thanks, Kieran, and welcome everybody to this presentation. I thought we'd start by reviewing important notions from our first estate planning session. So, when you're an attorney, you can act and make decisions in the grantor's name, so the person who gave you that authority, while he or she is alive. When he or she dies, your powers of attorney instantly cease, and the will now dictates what happens. So while they're alive, however, their will is not in effect, and by extension, you as the executor have really no say in managing their affairs. The instant he or she dies, however, you as the executor are charged with managing their estate and making the decisions you're empowered to make under the terms of that will. So let's quickly review things to know if you're somebody's attorney. So a power of attorney, or POA, is a document by which the grantor, the person who grants you that power, appoints another person or persons, the attorney, to act as a substitute decision maker on their behalf. Powers of attorney fall under two main categories. When people, grant the powers of attorney, the most common seen power of attorney, or POA, is a power of attorney for property, giving the attorney the power to manage the grantor's financial affairs and physical affairs. Another important power of attorney grants the attorney power to make decisions concerning the grantor's health and well-being. We have discussed both POAs in our first estate planning educational track webinar, which is available to be viewed on our website at www.senecallions.ca. So your powers of attorney for property could be effective immediately upon signing, regardless of the grantor's capacity. Alternatively, they could be springing or contingent on a condition such as the incapacity of the grantor. Important you know the difference. If your powers are contingent on the grantor's incapacity, for example, you might need to get an expert opinion from a doctor or a psychiatrist or something before you can act. So that might cause issues. And then again, there may be more than one attorney. And if so, you must determine if you could act separately or if you need to act together. And if you have to act together, do the decisions need to be unanimous, or if a majority of attorney need to agree? If nothing is mentioned in the power of attorney, the default is unanimous. So make sure you have a look at that. And if it is a unanimous, is there a dispute resolution mechanism in there in case you can't agree? Finally, what is the scope and terms of your powers? Are they limited in any way? And just remember, because there's a misconception there, even your spouse can give instructions without a power of attorney for property. So for a power of attorney for property, you have the duty to always act in the best interest of the grantor. You also have a legal obligation to keep accounts and reports to the grantor or to interested parties when required to, in some cases even to the courts. So as an attorney for continuing power of attorney for property, you can act when the grantor is able or unable to act on his or her own behalf, so they don't have to be disabled. You can make financial decisions, including investment decisions. You can sell or purchase property in the name of the giver, but there are things you can't do. You can't give away the grantor's property. You can't make a change in the will or a beneficiary designation on an RSP or an insurance contract. So, at the end of the day, and we talked about this in our previous session, that if the testator, the person writing the will, is not capable anymore, you're stuck with that will, and you can't change the beneficiaries anywhere on any insurance policy, for example. So things have to be done while they can, because you as the power of attorney cannot do that. Other things you can't do, you can't act in your own self-interest. You can't delegate your authority unless it says so in there specifically. And the other thing people don't realize is, even though you are the attorney, you have a power of attorney, You can replace them in their personal duties, example, as a director in a company or as a trustee on a trust somewhere. Those are personal, you cannot replace them. So powers of attorney for personal care, by opposition to powers of attorney for property, the power of attorney for personal care is only effective if the grantor cannot act. Whereas with a power of attorney for property, you can act as the attorney even though the grantor is able to. In this case, you cannot. You have no authority if they can give direction, which sort of makes sense when you think about it. So again, there might be more than one attorney. You might need to act together or independently. Often for those we see independently in case there's an emergency at a hospital. You might be called upon to make medical decisions, but also be asked to decide on living arrangements, ongoing care, diet, etc. Often, those powers could be limited by what we call a no heroics measures clause. That basically takes a decision away from the power of attorney in situations when there's no hope for the patient. The patients gave direction in the power of attorney documents themselves, directing to keep them comfortable, clean and fed, etc., free from pain, but to let them go. So technically the pulling the plug decision is not yours. They made that decision themselves. So if there is no power of attorney for personal care in Ontario, there is a schedule of who can give direction to the hospital. For example, there is a schedule who comes before whom. Now let's review a few important aspects of wills that we already discussed in our first installment. So a definition, what's a will? It's a legal document. It gives the executor the directions and powers to manage and dispose of the testator's estate. You know, there are many types of wills in format out there. There's mirrored wills, there's all kinds of things. And there are formalities that make a will valid. You know, a will could be declared invalid if it's not witnessed properly and stuff like that. We all discussed this in our first installment. And although every will is different and specific to the testator's situation, there are clauses we often see in all well-constructed wills, right? They revoke the prior wills, they name the executors, they explain how they want their assets and their estate to be distributed. They often give the right for you, the executor, to retain and pay for experts. And one of the important things they say in there is this a paid job or not? And if it is paid, well, obviously it has to be well established in the will how you get paid. There are some wills with special clauses. You know, there might be a charitable strategy in there. In some cases, wills do create trusts for the beneficiary. So they will discuss that in there. You may or may not be called to be the trustee of the trust. There are equalization clauses. And very often, you know, you are limited in what you can do with the investments unless the will says, you know what, we trust you, you manage the investments and stuff like that. So let's start and get into the meat of this discussion. So the first thing we talk about is whether you accept the job or not. Now, even though you said years ago that you would do the job, you have no obligation whatsoever to accept the job if you don't feel you can or you want to. But just to be clear, if you do one act as attorney or executor in this case, you're deemed to have accepted the job. So if you make the funeral arrangements, you can't say that's all I want to do. Once you are there, you are the executor. So be very careful when you're named executor. If you do not want the job, do not do anything. In what you might do, especially if there's an alternate executor, is to let the other one person you don't want to do it and let them do it. If you do that one thing and you don't want the job, you got to go to court and ask to be excused. If there is no executor or attorney or no will, there's a vacuum there, obviously, and then the public trustee would probably step in. And obviously they're very busy, they charge, and you may or may not be the priority. And at the end of the day, they may not do things exactly the way you would have wanted them to. However, if you are not named as executor and you want to be executor, you can always petition the courts and ask for that. We talked about probate in our previous installment, and although very often the bank will not act unless they see a probated will, which declares it valid. Just to be clear, you don't need a probated will to be the executor. You can start acting the moment the person died if you are the executor, and unless somebody objects, and typically would be a bank or somebody like that, investment company, or you need to transfer property, real estate, then you don't really need to have a probated will to do that. One of your biggest jobs, and we'll get to that a few times, is one of your biggest jobs is to act fast to preserve the estates. You might need to preserve it against creditors or thieves, or heck, even very aggressive heirs who think everything's theirs, and they start taking things for themselves, although they're not allowed to. If they do that and the estate is dilapidated, well, the other heirs can sue you. So make sure you do that too. Again, what we are trying to show you today is that this here is a job. It's not a privilege. Don't feel insulted if you're not chosen as executor necessarily. You may not want the job. So let us give you a quick idea of what the job might entail. And this is not an exclusive list, but it gives you an idea. Obviously, when the person dies, you need to secure the original will, which is often an issue. And you need to determine if you are or who else is the executor, and you have to review the instructions. Some things have to happen quickly, like, for example, if there's a clause on organ donation and how you dispose of the remains. And again, back to take possession and control and preserve all the assets, the bank accounts, the house, the tools in the tool shed, everything. Then things that have to be done on a timely basis, obviously, the obituaries, the announcements. And at some point, you might need to retain professionals quickly to advise you how you should be doing the job and maybe, answering your questions. One of the things we often suggest to our clients is, listen, to basically bring the temperature down often, why don't you arrange a meeting, just a first meeting with the heirs and the stakeholders, so people understand what they should be expecting. Managing expectations is a big part of it. You also need to quickly ensure that the family's immediate financial needs are met. If there are children or dependents or whatever, and everything is locked up, as the executor, you might need to make sure everybody's okay. Then you get into things that you maybe aren't as time sensitive, but still are important, like reviewing any marriage contract, family law issue, or dependent relief issues that you might need to act on quickly. And then next things, you claim the benefits, the CPP death benefits, insurance death benefits, or whatever. You might need to cancel, in some cases, switch government and private pensions for, switching the spouse's name or whatever. And in some cases, you might want to start the probate process. Probate is a complex issue. We often suggest that you hire a professional to help you out with that, because even an honest mistake could cost you. You might need to cancel subscriptions, phone, internet, social media, etc. And you might need to generate cash just to manage the estate and make sure everybody's okay. Then another thing that obviously you have time to do, but it's prepare and file the terminal returns. Those are the returns for the deceased for that stub year, that part of the year where they were alive. All the income for that part of the year, if they pass away in June, well, from January to June, what did they earn? And you have to pay a tax return for that. Pay taxes, probate, whatever you need to. But then you get into the maybe longer term things, like possibly implement a philanthropic or charitable strategy. You would have to investigate and pay valid bills. You're not expected to pay bills that aren't due. And trust me, some people will try and pass a few through you. But you have the authority to decide, if you need to pay or not. And if they disagree, they can always sue the estate. You need to collect monies owed to the estate. People often don't know that. They don't know that the money is owed. So again, very often people go through mounds and mounds of documents when things are not prepared. Again, every once in a while, you need to communicate with the heirs. not easy managing with all the possibilities when people are emotionally distraught. You might have to manage their business, their company. Maybe you have to act as trustee for testamentary trust or just establish a trust. And the other thing you have to realize that the estate itself every year has to file its own tax return. If it lasts for a few years, you have to file the estate tax returns. Eventually, when all is done, the taxes are paid, everything is filed, you must require a CRA certificate of clearance that basically says, okay, you are allowed to distribute the assets at this point. Now, again, the CRA, to be clear, certificate of clearance doesn't mean you can't do it before. I mean, you can do whatever you want, I guess. But if there's tax owing and you have given away everything, CRA can come after pretty much everybody, including yourself, if there's no one left to pay the taxes. So as an executor, I would not pay off and empty the estate without getting CRA's approval for that. And finally, the last thing you want to do is distribute the estate. Now, those are examples of things you might need to do. There might be more, but there's some things you can't do, right? For example, assets that are co-owned with right of survivorship. So for example, a couple owns a house with right of survivorship. When one of them passes away, that house is automatically de facto the property of the survivor. It doesn't go through the will, doesn't go through the estate. It's just automatically them. Same with most joint investment or bank accounts. Automatically, as they die, it becomes the other ones. Now, there are circumstances where you got to be careful because courts have started to say that, if you're added to your mom's bank account, you're really there in trust to help her out, and that money is not necessarily yours, but it will go in your hands, and you have the responsibility to split it with your siblings or whatever. So it's not yours; you're getting it in trust, but it doesn't go through the estate. Is my point. So as an executor, you don't deal with that. If insurance designations go directly to people instead of to the estates or RSPs or TFSAs, then you do not deal with that as the executor. It bypasses you and the estate. And don't forget that these assets are initially not available to pay the estate bills or to distribute to the heirs. Quick word on death and taxes, because you will have to deal with taxes if you are the executor. So let's quickly review the implications of death and strategies to avoid them. Now, we talked about this in 2 or 3 of our previous webinars. So this might be a review for some of you, but for some of you, it might be new. So how is an estate tax in Canada? Well, let's start by stating there is no estate tax in Canada. An estate tax is a tax on your assets, you see. So if you have $1 million in assets, you are taxed on that in the US and many European countries, not in Canada. We have probate fees. We talked about that, about 1.5%, give or take, in Ontario. I consider that a tax. But when you die, this is where the taxes come into effect. When you die in Canada, you're deemed, first of all, to have sold everything you own the moment before you die. So that cottage you paid for $50,000, that's worth $1 million in the Muskokas today, you're deemed to have sold it for $1 million, which means capital gains of $950,000, give or take, which means that you have to pay the tax, and then you're deemed to have repurchased it right away for that $1 million. So your new cost is $1 million. When you transfer it, the heir gets a cottage that costs $1 million. However, the estate owes about $250,000 in taxes on that. You also, if you have investments like rental units where you've depreciated them to save taxes all these years, the moment you die, that goes back into your tax as taxable income that year. Also, you're deemed to have taken all of the monies out of your RIFs and RSPs, and that becomes a huge payday for that day. So if you have $1 million in your RSPs, that is your salary for that day. So you have to pay tax on that. So I hope you're not surprised to figure out that a lot of those monies will be taxed at over 50%. Could be huge. So quick examples. I don't want to get lost in the numbers here, but a few examples. For example, if you have these different assets, rental units and all that, some things are taxable, some are not. In this example here, we see that there is about $3 million in tax liability. However, they have $7 million in cash, or in good shape to pay it, et cetera, et cetera. But we have to look at every asset you own, whether it's taxable or not, TFSAs or not, RSPs 100% taxable, capital gains 50%, et cetera, et cetera. But then the other thing, especially when you have corporations involved. So assume that the person who was deceased owned shares in a private company. They paid, $100 to open the company, and it's worth, $4 million today. So how are they taxed on that? Well, first thing is they bought shares for $100. They're worth $4 million. That's close to $4 million, or of capital gains. So a few $1,000,000 taxable that day. And if you want to get the money out of the corporation, well, the corporation, the company itself that has investments or assets, has to sell them so they become cash. So when they sell them, the corporation itself, over and above what's been paid, may have to pay tax on the capital gains of the assets in the corporation. And finally, the money is now cash in the corporation. You've paid the 2 levels of tax and you want to take the money out. Well, that becomes a dividend. Again, taxable. So basically, those assets are technically taxed 3 times. And to give you an example, of course, we'll get into that, there are time-sensitive strategies that you have, maybe, for example, 1 year, day to day, after the death, to maybe try and save money on those taxes. But to give you an example of this one, not to get lost in the numbers, on the shares themselves, there's maybe $1 million of taxes to be paid. Inside the corporation, under this scenario, net complicated tax, corporate taxes, but let's say at the end of the day, $250,000 to pay in taxes. That leaves you with about, $3 and almost $4 million in taxes to be, not of taxes, but of money, of cash to be taken out of the corporation. Part of it's taxable as capital, as dividends. Some of them aren't. At the end of the day, another 1.3. So in my example here, which is a realistic one, of the $4 million value of the company, about 2/3 of it ends up in the government's hands and 1/3 in the heirs or the estate hands. There are strategies to avoid that. Something that we can slowly get into here, but it's more part of a corporate tax seminar than this. But for example, you can, that first capital gains on the shares, there's a way, if you do things within a year, to eliminate that tax, and it takes planning with your financial advisor and your accountants to make that done. Personally, one of the things I forgot to mention earlier is when, as an individual, you were taxed by the sale of, the deemed disposition or the deemed sale of an asset, your cottage, I gave an example, or the RSPs. If the assets are transferred to your spouse, and spouse, I mean that from a CRA perspective, you don't have to be married to be a spouse. If the spouse receives everything, you can postpone the tax bill till the second one dies. So they basically say, we're not going to tax the widow right now, or we're going to tax them later when everything's done. Obviously, if one has $500,000 in RSPs and the other one has $500,000 in RSPs, and one dies, well, you end up with one person with $1 million in RSPs, probably a higher tax bill at the end. But anyways, in some cases, you can avoid part of that postponement, especially if somebody dies on January 2nd, had no other income. You might want to generate some income at a lower tax rate rather than at 53% later on. So that's one strategy. Among other things, when you die, you can have 2 or 3 tax returns for that same stub year. Your executor should speak, as an executor, you should speak to your financial planner or your accountant to see if that applies here. Very often we implement, and we help client implements, charitable donation strategies to reduce that. And CRA gives you some choices that you may be able to work with to try and reduce or avoid taxes. Again, your certified financial planner, certified executor advisor, or your CPA can help you with that. Now, another thing that a lot of people ask us about is, how long does it take to settle an estate? Well, anywhere from, I've seen 3 months, I've seen, well, some are 5 or 6 years old, they're not quite settled yet. It depends on the complexity, but it also depends on how you plan for it. So the main impediments we found over the years is surprise executors. You don't want anybody to surprise as being an executor. They don't need to know what's in your will, but you might want to let them know that, hey, you're an executor. This is where the will is. If there's anything, these are my thoughts. But please, for anything, do not put somebody's name in there without them knowing. That's where we get the most refusals to be, for people to be executors. Another big impediment we find is people just can't find the information they need. Where is the original will? Where are the legal documents that they'll need? Do you know what the subscriptions are? Are they, do they get the Toronto Star or whatever? I mean, do you know that? Do you have the passwords for their bank account or their Facebook account or whatever, right? We've encouraged a lot of our clients, and a lot of them actually prepare a binder with all the required information and keep it in a secured place, either um, uh, their lockbox at the bank or in a will at home, a safe at home or something, but keep it secured and accessible to the executors. Now, obviously, you don't want necessarily your will in the in the bank lockbox, because if the bank doesn't know you're the executor because the documents in this lockbox, you won't be able to get to it, right? Another thing that we found more and more, some people think that, if I have 5 different bank accounts and 3 different investment accounts at 3 different places, I'm diversifying. Well, that's another debate. You are not diversifying. We're all playing on the same markets here. We're all investing in the same sort of portfolio. So you're not really diversifying by having all that. But what we found is one of the jobs of the executors is to try and consolidate everything. And working with financial institutions, and honestly, I've just went through it not too long ago with a family member, where it took months and months and months to get a jointly held account between, the husband and wife. When the husband died, automatically that account was the wife's, but it took the bank about 6 months to agree to that. We had to go up about 5 or 6 levels to finally find somebody who understands that and to apologize profusely that shouldn't have happened, but in the interim, that happened. So the estate took an extra 6 months. It shouldn't have, just to get started. And the other thing is, very often there's just no estate planning. And we don't just mean the will. I mean, everything else that goes around that to make sure that things are easy. If there's no planning, things get muddled up very often. So again, people have, oh yeah, made a will 20 years ago. Well, you didn't have kids then, how are things going to work here? So a bit of planning, your estate could be settled in less than 6 months. We've seen 3-4 months in some cases. Everything was really planned for. So right now, we just a few little things we'd like to finish with, and I will hand this over to my colleague and partner, James Lyons, who will now wrap things up for us. James?
Thanks, Pierre. A lot of information there. Appreciate the wealth of knowledge. I'm just going to share a few final thoughts here. I do see we have a few questions rolling in, so I just want to take a moment to remind everybody that if you do have questions that are general in nature, please use the Q&A function on the side here, and we'll be happy to address your questions. And again, if it's specific to your personal circumstances, feel free to follow up with us after the presentation, and we'd be happy to address that independently. Okay, so thanks, Pierre, Kieran, everyone, for the wealth of knowledge that you shared here. And I think after listening to the presentations, one of the general takeaways that I typically have when we're talking about estates is that being an executor is a demanding job. Obviously, there's a lot of responsibilities, a lot of confusing legislation, all of those types of things to consider. It can be demanding, but you can also seek help and guidance through it and know that you're not alone in that task. Our team, as certified executor advisors, we help our clients who are executors or our clients' executors find their way through the various odds and ends of, estate administration. Typically, we find that good preparation is the most important part in terms of simplifying and speeding up the process. That being said, of course, every circumstance is different. And in the event that we do run into hiccups, we work with many professional partners, including professional trust and estate trustees, to help you manage the estate. Another suggestion that we often provide to our clients, and this would apply to anybody, is that we recommend that if you have assign someone as your executor, your trustee, your power of attorney, introduce them to your professional advisors, introduce them to your accountant, your financial planner, your lawyer, well ahead of the time. And that's something we recommend our clients do as well, is make sure that the parties that are involved in administering your estate are comfortable and familiar with your A team, so that when the time does inevitably come, they feel comfortable reaching out to those individuals to assist them through the process here. So I do see some questions rolling in here, Pierre. I'm going to just start to sort them on the side here. But while I go through the questions on the side, I'm just going to share some information about the rest of our team here. So you've met Kieran and Pierre here already. Senecal Lyons and Associates provides the services of 4 licensed advisors and financial planner. You'll see our other partner, Ty Wernberg, included here. And we're supported by a group of talented people that make sure our client service is second to none. Our family office provides comprehensive and complete financial planning services to successful business owners and professionals, as well as high net worth families with complex financial planning requirements. When you retain our team at Senecal Lyons and Associates, not only are you getting the expertise of our direct team, you are also retaining the IG Private Wealth Management expert team, which, as you can see on the side here, consists of a variety of different experts. We like to think we're pretty smart and that we know a lot, but that being said, we don't have a monopoly on good ideas. And when we do run into situations that may warrant additional expertise, we have those folks here ready and waiting to help us. One of the comments I often like to just draw attention to here is that we expect most of our clients or potential clients are working with other professional advisors, business managers, accountants, real estate agents, lawyers, whatever the case might be. At Senecal Lyons and Associates, we like to be part of the A team. We're not looking to take on anybody else's job. So we want to work with your lawyers, with your accountants, make sure that any strategies that are being recommended by your other professional advisors make sense in the context of your financial plan. Vice versa, any strategies that we're suggesting as part of your financial plan, we want to make sure that they're aligned with your accountant, your lawyers, have that cohesive A team in place for you so that you are really getting the best out of everybody. Could I get a slide forward here? Yeah, thank you. So again, at the end of the day, our clients are, potential clients are at the center of everything that we do. And we do everything in our power to meet your ultimate goals of family, business, financial success, whatever that means to you. We take the time to listen, make sure that we understand what your plan entails and ensure that we're keeping you informed of anything that needs to be done to ensure that we're achieving your goals here. So touching a little bit more on IG Private Wealth Management as a whole, Senecal Lyons and Associates operates under the IG Private Wealth Management brand, part of the IG Wealth Management companies. We're actually going to be celebrating our centennial anniversary next year in Winnipeg. It'll be 100 years of IG. IG is one of the biggest asset managers in the country and has a focus on providing financial planning services to Canadians. And we have a focus on being the best financial planning organization in Canada. And if we take a look forward here, you'll see how IG Wealth Management fits into the Power Corporation of Canada structure. I'm sure some folks here will recognize some of our sister companies, Canada Life, Wealthsimple, Mackenzie Investments, to name a few. We obtain strength and scale as part of the Power Corporation group of companies, and we're uniquely positioned in the Canadian marketplace, having all of these professional partners, expanding out here into some of our preferred partners from investments, insurance, and banking. IG has made a concerted effort to partner with the best providers of a variety of different financial services products. Again, I said before, we don't pretend to have a monopoly on good ideas, and we don't pretend to have a monopoly on good products. So we've gone out into the market to partner with the biggest and best to make sure that our clients have the products that they need to achieve their financial goals. And then finally, just a quick note here, and then we'll transition into some of the questions that we have. IG has made a large commitment to giving back to the community as the target sponsor of the Walk for Alzheimer's annually. And just a quick note here that our team has created our own charitable giving fund. We think it's important to give back to the community that we operate in. So in 2021, we opened our own charitable giving fund, which grants a portion to charities every year. And this year we have decided to support Diabetes Canada towards paying for a local child's week at a summer camp to help them learn how to cope with this chronic disease. If you're interested in learning more about charitable giving, please refer to our website to, again, look at some of the previous information and webinars on philanthropy. All right, Pierre, I'm going to bring you back in here. We've got quite a few questions, so time pending, we'll try to get through all of them here.
Sure.
Pierre, can you hear me?
Yep. Can you hear
Perfect.
me?
Yeah,
All right.
loud and clear. Okay, so a number of questions here. I'll start with one that I hear very frequently. Are there any pros or cons to online will makers, legalwills.ca, Willful, something along those lines, versus the traditional route of working with a lawyer to prepare your estate documents?
Well, let me start by saying that between those, e-wills, very generic and probably not well conceived for your needs, between that and having nothing, you're probably slightly ahead because, as we mentioned in our previous webinar, not having a will has severe consequences. Having a will, at least you're starting to direct things. What our experience is, if you use an e-will like that, especially if you have any complexity whatsoever, you are begging for problems with the heirs. I mean, I can tell you tons of stories of where the testator, the person writing the will, had the best of intentions but created havoc. If I may, I'll take a second here, where somebody decided at some point that the daughter, he had a cottage and the riff, that's all he had left, worth about $700,000 each. So the son liked the cottage, the daughter didn't. So he said, okay, the son can have the $700,000 cottage and the daughter can have the $700,000 riff. So he put his daughter as beneficiary to the riff. Well, unbeknownst to him, because he didn't have advice from lawyers or financial advisors, the financial institution wrote a check for $700,000 to the daughter. But as I explained earlier, that RIF is taxable, and there's about a $350,000 tax bill on that. Well, she got the $700,000. Guess who got the bill? The estate did, which means that the estate was left with a cottage that had capital gains on it, so another $100,000. So call it $450,000 tax bill and the $700,000 cottage. That's what the son got. Net $250,000, had to sell the cottage. Bit of advice would have gone a long way to avoid that situation. So yeah, those e-wills and those, just go online, better than nothing, but expect problems. And one of the things we ended up in our last presentation was, if you think making a will is expensive, try not having one. You'll see it's a lot more expensive.
Yeah, thanks for that, Pierre. It certainly makes it more difficult for the executors. And if you're taking the time to go through the process, probably in a lot of circumstances, makes sense to get that professional advice, like you suggested here. Okay, I got an interesting one here, Pierre. Is it wise? So we talked about the process of probate and probating a will and things like that. Is it wise to create a living trust to avoid going to probate?
There are advantages to it doing that and disadvantages to doing that also. Among the advantages, obviously, is if you transfer your assets to a trust, and if you're over 65, you can do the alter ego trust, which won't get into. We went into that early in the other seminar, but basically there are all kinds of advantages. One of the big advantages is when you die, the trust doesn't die. So there's no probate, there's no capital gains cost or anything, because that happen. However, depending on the trust you build, obviously. And because you see, when you get a will probated, it becomes public knowledge. Anybody can go online and figure out, and see what your will was. Well, if it's in a trust, that doesn't happen. So there are advantages. However, you do have to manage that trust while you're alive. So there might be additional costs there for that. There are tax implications when you die. That, if when the trust, when you die and your assets are in the trust, if the trust happens to die, like in a spousal trust or an alter ego trust, then the trust has to pay capital gains at that point. Capital gains, whereas we have what we call a graduated rate. So, you have tax brackets from 20% all the way up to 53%. Trust has one tax bracket. It's called 53.53%. So there are advantages and disadvantages to doing that. We have a few situations where it made sense, and we had our clients transfer their assets to that alter ego trust, or that replaces them, if you want, as a person, if you're old enough, for all kinds of reasons. But if the whole idea is to avoid probate, it might cost you a lot more than 1.5% of the probate fee when you die, to have that trust going for years. So every situation is different. Some cases we've advised it, some cases we haven't.
Thanks for that, Pierre. And I think one of the most frustrating responses I give to clients and prospective clients sometimes is it truly does depend, right? Every set of circumstances is different. I wouldn't say there's a hard and fast rule to, is this right? Is it right for you and what you're looking to accomplish?
That's right.
Pierre, you mentioned something, so I'm gonna pivot here. I've got a question just based on what you were chatting about. This wasn't one of the included ones, but you mentioned the graduated rate estate and the benefits that will allow your estate to have in terms of the graduated tax rate. Talk to me a little bit about the, I guess, circumstances that you would need to maintain in order to maintain that graduated rate estate. Is there anything you could do to I guess, eliminate that provision within an estate?
Well, let's start by explaining what the graduated rate estate is. And I didn't really touch upon that a lot in this seminar as much as the previous one. But, I mentioned that a trust has one tax rate, 53%. The estate has what we call a 3-year period in which it could be a graduated rate estate, which means that our lowest rate in Ontario is just over 20%. So for the estate, for the first 50,000, you pay 20% tax, and then it goes up to 53% if you're over $250,000. Now, if you already make $100,000 a year and you get the income from the estate, it's going to be added at the higher tax bracket. So it might make sense for those 3 years to keep that money in the estate, where the estate on that same, call it $50,000, will pay 20% instead of 40% in your hands. So very often in wills you see today, that used to be, before this happened, that you had a year to finish the will, otherwise you had to explain why. Well, now very often in the states we see today, they typically say you can, as the executor, decide to keep the estate going for 3 years and benefit if it makes sense for the heirs, benefit of that lower tax rate in the estate that they would have personally for at least those 3 years. Now, in order for that to be there, the funds have to come from the estate only. You cannot put your personal money in there, because then you taint the estate, and then you lose that privilege. And there are a few things you need to do. That's why I tell people in that situation, when things are taking time with the trustee and all that, and you got to pay the funeral bills, don't pay it yourself, because then you've just included your money into the estate, and you've tainted it, and you cannot do you do not get the benefit of the lower rates. So those are the things that might influence that. But bottom line here, an estate is a trust. A trust pays 53% tax on all its income. We'll get into how to get away from that in our other webinars. But the estate has a special condition, a 3-year graduated rate estate clause. That means that In Canada, you can have the lower tax rates on the estate for 3 years. And in some cases, it makes sense to keep the money in the estate for those 3 years and pay less taxes overall.
Excellent. Thanks for that, Pierre. And it's seemingly a phrase that we're coming back to, but it does depend on the circumstances, right? No, no hard and fast rules here. Okay. One of the questions we got here, Pierre, and I'm just going to go through this, make sure I've got the details. So as part of the presentation, you had mentioned the different ways to own a property, right? You know, tenants in common, joint tenants, things like that. If someone is a joint tenant on a property with a parent who passes away, does that mean the property does not go to him immediately, but goes to the estate? So could you just touch on the differences between tenants in common, joint tenants, and how that would, I guess, operate as part of an estate?
Yeah, so there are two ways you can hold property in Canada jointly, that is. You can either, you can be joint tenants, and the joint tenant means that when one of the two or three, whatever, die, then the survivor or survivors own it outright, does not go through the estate, does not go through, I mean, typically you'd have it recorded at the land transfer office or whatever, but I mean, it's automatically there. It does not go through the estate. If you are tenants in common, which means that if I own a house with you, James, and we own it 50-50 or 70-30, whatever, as tenants in common, it means that, you know, if I were to die first, then my 50% doesn't belong to you. I can will it to whoever I want and go through my estate. But if it's joint tenants, which means that it's owned jointly with right of survivorship, so the survivor gets it all, doesn't go through the estate, doesn't go through the will. Same thing for bank accounts, investment accounts. So you either own something with right of survivorship, which is, I would say, 99% of the investment accounts or the bank accounts, or you own it without right of survivorship, at which point the share of the deceased goes through the estate.
Perfect. Thank you. Okay, so just got a couple of more here, and notice we're running up against time here. So maybe I'll get to a couple more here, Pierre, and then we can address any more that come in after the presentation here. What if an executor was in a position where they either refuse the role or become incapacitated after taking on the role? What would the options be at that point?
Well, obviously, if you refuse the role and you haven't done any act, you haven't done anything as an executor and you refuse a role, then hopefully when they made the will, they had substitutes. If not A, then B. If A and B can't, then C. So if that doesn't happen and you end up in a position where there are no more executors left to take on the job according to the list, then it's the same thing as if there were no executor, and then the public trustee would come into act and with their own priorities and timelines and, you know, and workload. Or somebody else can go to the court and say, hey, I am the son or daughter or whatever, or the niece and nephew or whatever, and I would like to have this job. The judge will hear that. The public trustee would be happy to have you take on the job. And if none of the potential heirs object, then it's usually a no-brainer. However, you know, there are costs to that. You might have to hire a lawyer, there are course costs and all that. So that is how you would get around that. And if there's nobody else, then the public trustee will do it whenever they can.
So with that in mind, naming alternates would be an important part of trying to avoid that.
And as we said in the previous one, please don't name somebody much older than you, because they may not be around by that time. It's always good to have people your age or younger, but that's, you know, rule of thumb.
Yeah, absolutely. And, you know, if you do name someone older than you, maybe have some contingencies that are, you know, younger than you. And if you are in that circumstance, maybe consider reviewing the will a little bit more frequently than you would have otherwise.
Assuming you can.
Absolutely.
Assuming you are able to.
Okay. I'm going to get to the last question here and then we'll wrap it up here. How much does your services cost to advise the executor?
Oh, okay. That's a good question. the way we charge our fees basically is based on the assets we manage for our clients. It's a weird situation where we give all this tax advice, estate advice, retirement advice, and whatnot, but we don't charge for that directly. We only charge a small percentage of the investments we manage for you. So in that sense, our fees for something like that are included in the client's asset management fees, if you want. So people will not get an invoice from us for all the additional services. They are included in there. So for example, a client that has between 1 and 3 million with us will typically pay 0.9% a year. That is what pays for everything.
So just to reiterate, there's no invoice for service or
No.
A bill. It's simply covered by the advisory fees, pay for all the services.
Yeah, exactly.
Excellent. Okay, I know we're up against the time here, so I noticed, Pierre, we didn't get to a couple of questions. So if we didn't get to your question specifically, we will get in touch afterwards to address that. And if any questions have come up in the course of today's discussion that you have that are of a personal nature, feel free to reach out to us independently. So thanks everyone for joining our presentation today. I hope you found value in some of the content that we shared. Again, estate administration, it can be complicated and overwhelming. Trying to do anything we can to help simplify that process and understand the ins and outs of it. Can we just slide back quickly? Just wanted to draw attention to some of the webinars that we've done in the past here. We do like to produce, as Kieran mentioned from the outset, regular content on various financial planning subjects that may affect our clients or the community. So if you go to our website at senecalliance.ca/video, you will see all of our previous presentations. If you have any interest, they're on demand. Feel free to watch them as often as needed. We do have one last presentation coming up in November, which will be talking about insurance as an asset class. So if you have any interest in that, please feel free to tune in here. Okay, so yeah, once again, thanks for joining. If you want to learn more about our team and the services that we provide, our website is there, again, senecalliance.ca, to view the services and our team. And if you have any interest in following up with us to book an appointment and maybe learn about administering an estate or whatever might be the case, feel free to book a meeting through the links provided on our website. Okay, on behalf of everybody, want to say thanks, Pierre, thanks, Kieran, thanks to all the presenters for the wealth of information that you shared today. Thanks, everyone, for joining, and we will see you next time. Thank you very much.
Thank you all.